Hi, my name is Robert Chelle with Chelle Law, and my law firm assists professionals with employment contract issues. Today, I'm going to talk about the consequences of breaking an employment contract. The first issue is what is considered breaking a contract. I think some people think just exercising their right to terminate the agreement is breaking the contract. I don't think of it that way. When I think of breaking a contract, meaning you don't give proper notice, you just simply leave the job without following the terms of the agreement. In that scenario, what are the potential consequences? So let's say a professional's at a job, it's not working out for whatever reason. In almost any employment contract, there's going to be a section that kind of discusses the ways the contract can be terminated. And then within that section, there'll be what's called without cause termination. And without cause termination simply means either party can terminate the agreement for any reason at any time with a certain amount of notice to the other party, normally somewhere between 30 to 90 days. So let's just say an employee, the professional walks in on Monday, says, I'm leaving tomorrow, but they had a 60-day without cause termination notice requirement. Well, if that does happen, the employer could then potentially go after, and when I say go after, I mean legally go after them, sue them for breach of contract. And then when you sue somebody for breach of contract, there can be a number of damages involved. So there could be lost profits for what they would have expected that employee to generate during that 60-day period. They could also go after the replacement value. So if they had to find some kind of short-term replacement that was very expensive, they could go after the employee for that. There could be damages for recruitment fees in trying to find that employee's replacement. They could maybe go after them to get back signing bonus, relocation assistance, licensing fees, credentialing if they're a healthcare provider. So yes, if you do break a contract, meaning you just simply walk out and don't fulfill the terms of the agreement, there could be a number of things that the professional could be liable for. Now, a lot of times when I'm having a consultation with somebody who is unhappy, they just say, well, these are all the things the employer is not doing, right? So they're not paying me my bonus in time, or they're making me work more than it's in the contract, or I'm having to take, twice as much call as they said I would. Okay, well, just because they're doing it or they're breaking the contract doesn't mean you can just leave and then cite that as a reason. If you believe the employer is in breach of contract, you need to provide them with written notice that states you are in breach of contract for these reasons. And then normally there'd be some language that states you can cure the breach, usually somewhere between 15 to 30 days. And then if the employer does fix whatever the problem was, then the employee cannot terminate the contract for cause. If you can terminate it for cause, usually it can be immediate, meaning you give the employer written notice that they're in breach of contract, the employer does nothing, then it would be the option of the employee to terminate it immediately. So that is simply different than the employee just breaking the contract. You have to go through it to protect yourself, the terms of the agreement. And even if the employer is not fulfilling their terms, you still have to give them notice. You still have to wait for the cure period. And then if they fix whatever the problem was, you still can't just break the contract and jump immediately to a new position. So to protect yourself, read the contract, see how the contract can be terminated either for cause or without cause. Follow the requirements. So if you have to give 60 days notice to terminate the agreement without cause, you have to give 60 days notice. or you could potentially open yourself up for a lawsuit and some kind of damages. Last thing, there will be a section in the contract that kind of states how effective notice can be given. So what I mean by that is it will state, to give proper notice, you must send either certified mail, hand delivery, a written letter to, the address of the business or the attorney of the business or whatever. If you don't give effective notice, meaning you don't follow that notice section, it would not be considered a proper termination. And in that scenario, the employer could simply say, well, you owe us another 60 days until you give us effective notice or whatever. So follow the termination section, follow the notice requirement, and that way you can avoid having to either pay anything back to the employer or have to pay damages for lost profits, recruitment fees, the things I went over at the beginning of the video. Hopefully that's helpful. If you have any questions about your employment contract, you can always call us at our phone number listed below in the description, or you can reach us through our website, chellelaw.com, CHELLE law.com. And I appreciate you watching the video. Thanks.